Hello, welcome, welcome, welcome. You know, when you're sitting down waiting a little intro video to come on, my apologies. We're running a little late this evening. We had a bit of trouble with our platform. Welcome to the virtual world. So this evening is our 47th episode 47 of COVIDCastJA. And we want to welcome everybody to another episode. We'd like to thank our sponsors, the NCB Group and the JMMB Group. And what a year it has been. And yes, it has been it's just about a year now since we started COVIDCastJA, and many of you have been with us from the start. So we've gone through so many different episodes over the year. We have talked about your finances. We've talked so much about pivoting. We've talked about all the different types of pivoting. We've gone through labor laws, contractual provisions in your labor contracts. We've talked about redundancy, laying off. We just went through an entire series, technology, that we talked about technology. We talked about technology for about 7 weeks because we are starting your MSMEs on your technology journey. So we're in another set of programs, and one of the things that we keep getting questions about is just some hidden little things when you're running your business and you're, as Jamaicans say, cutting and going through in life, and some things that sometimes we're not thinking about, and they pop up. So we're going to be looking over the next several weeks at things like contractual clauses that you really do need to pay attention to, because a lot of times we get the contracts, we hear that they're standard and we just sign off on the contract and we go about with business. So we're going to be talking about things like that. And then we're going to be talking tonight. In fact, we are tonight is part 1 of a 2-part series. This 2-part series, yes, that we're talking about the importance of a will. We're talking about willpower. And we've gotten this request from several of our viewers. Can we talk a little bit about estate planning and will? So we're going to be getting into that. And tonight, we're actually going to start looking at checklists, things you need to take into consideration when preparing your will. But we're going to go a little step back, because sometimes the issue is that we're incapacitated. We may go into surgery, and sometimes there are complications, and we are unable to conduct our business over a period of time. What are some of the things that we should have planned and in place in the event that we are incapacitated? So we're going to look at that, and then we're going to look at the checklist for wills. And next week, just a bit of housekeeping. Next week, Thursday, is Holy Thursday. It is also technically the start of a bit of a lockdown. So what we're going to do is we are going to take a break for next week so everybody can get their house in order. And we return the following week, Thursday, which I think is April 9th. So the first episode in our Willpower series, you like it, Willpower, is tonight, and then we return 2 weeks from now, because we're going to take a break on Holy Thursday. We're going to return 2 weeks from now to do the second part, and we will have Attorney at Law Camille Facey in part 2, and we're really going to get into the nitty-gritty of all the different considerations with the wills at that time. So tonight I am going to play 2 roles. Tonight I'm host and I'm also presenter, because some of you may know that even though you see me on this show, like in the days, I'm a lawyer. So I'm going to start the series off tonight, and we're just going to talk a little bit about things that you need to have in place. Now, for those of you who see episode 47 up, and you're saying to yourself, how many episodes have I missed? 46. Where can I find these episodes? Smallbusinessportal.com. You can go also right to our Facebook page, and you can get the information. Some of you are saying, this technology conference that I heard about, where am I going to find the information on it? It's going to be uploaded on YouTube. I think next week we'll give you all of those details. Shelly-Ann, I see you. Kurt, good evening. Opal, Trude's there. Maxine, Rhonda, I see you. So tonight, ladies and gentlemen, is part 1 of Willpower. And tonight I am your presenter. My name is Rochelle Cameron. So tonight I'm presenting, and we are going to have another guest who actually has a platform that assist you in pulling together your will, because we're also, remember, everything is technology. No, so remember we used to just go buy a will form. No, there are platforms available that can assist you with the preparation of your wills. Look on that. So why are we talking about this? Now, recently, I had to consider, as a good friend was going into surgery, a list of certain things that I thought it was necessary that he had in place as he was going off into surgery. And you know, a lot of times we do have the conversation about wills, but we don't have the conversation about living in peace. What happens when we're incapacitated? Producers, can I get some slides, please? Now, what we're talking about tonight is how do we reduce complexities in the event we are unable to conduct our business? How is our business, and when I say business, I mean your personal affairs and your actual business affairs. Ernst Easy says, estate planning takes a huge weight off your shoulder. It certainly does. Producers, can I get some slides? While those slides come up, I am going to, thank you. Can you take me to the next slide, please? So while our slides load, I'm going to start talking about the checklist of some of the things you need to have in place. And you need to ask yourself certain questions. A lot of these things you will also see go across whether or not you're planning to live in peace or you're planning to rest in peace. And we know that a lot of us don't want to have this discussion about death. The only thing that is really sure, though, is death and taxes. Death and taxes. Now, let me tell you, as we are thinking about living though, and when we do have part two, we're going to look at things like power of attorney, living wills, because this is all about putting yourself, your property, your family in a position that life can still go on. Again, living and resting in peace. So you ask yourself some questions. Where are my documents? And a lot of times we don't know these, we don't have these answers. Your car title, where is your car title? Now, if you have a car loan, it is likely that the original of your car title is with the bank because there's a lien on your car. So that would mean that as you're making this list, you're also talking about the location of these documents. So you would check, and you know, sometimes it's good to even check with the bank. Do they have a copy? Can they find the original of your car title? Now, you may have already paid off this vehicle and you've never collected the car title. This is a great time for you to note that you have not collected the car title and to get it and have it in your possession. What about your house and property titles? You know, what about the land that you have, the house that you live in? Where are the titles for these properties? Are they with your financial institution? Did you get them a couple of years ago and put them in the socks drawer and nobody actually knows where they are? This is a great opportunity for you to just pull these documents together. Your insurance documents, where are they located? Any key contracts that you may have signed, did you just have them in your email? Are they printed off? Are they in a file? Are they properly noted? Is your filing system in order? Do you have any other patents, any official documents? Do you, and this is in the situation where, for example, you are going into major surgery and there's potential of a long recuperation period, or you're unsure of what the outcome will be. Do you have a fully executed will? And we're also going to be talking tonight about preparing your will. If you do have that fully executed will, where is it? Where is it? You have to ensure that somebody knows where to find it. Are there any transactions that are still underway, a purchase of a house, for example? Take some time to pull all of these documents together, your birth certificates, your marriage certificates. I say this weekend we're going down on the first lockdown in Jamaica. It's a great time for you to stop and actually go through some of these documents and note where they are located, and those that you actually need to go and collect, ensure that the transfers are done on car titles, property titles, etc. Can I get the next slide? Now, one of the things is, we say to ourselves, okay, I'm going to go into surgery, I don't really want nobody know my business, So how we don't want anybody in our finances. But I always say it is very important that you have one or two key persons that you can trust. Now, these don't need to be persons that you just laugh and have a drink with. These are persons that you can trust to actually get things done. These are persons that you can trust to manage your affairs because they actually have the capacity. And very importantly, they're not going to interfere with your finances. So they're not going to thief your money because you may have to give them access to certain finances while you're incapacitated so that your business can continue. Next slide, please. I see Opal Reed says, yes. Hi, Opal. Now you need to create a list of recurring expenses and make arrangements for payment. Now, just to take a step back, whether or not you're going into major surgery, what we encourage you to do is to review this list. It is available in our weekly SME memo. And ask yourself, just do I know where these things are? Because these are also things that are important for your estate planning. And this is information that you really should have at hand. Truths. You can write a will. We're getting into wills in a couple of slides. So just hold on a second. We're getting into the wills. So create a list of those recurring expenses and please make some arrangements for the payment. How is your mortgage paid? Does it come straight out of your account? Or is it, for example, that it comes out of one account, but you actually have to transfer money from bank A to bank B for the mortgage to be paid? How is your mortgage to be dealt with? Your car payments, the same thing. How are your car payments going to be dealt with? What about utilities, your electricity, your water, etc.? Do the bills come to you electronically? Who will have access? Can you do a prepayment of those bills? Your insurance, health and life, very important to ensure that they do not lapse at this time. So put arrangements in place for their payment. Khalil says, is it best advised to leave my trusted attorney in charge of executing my will? We're going to get to that, who your executors of your will. So this section, we're talking about if you're still alive, but you're in a coma, for example, so you're unable to conduct your business. What are some of the things that you needed to have in place? If you're going into major surgery, you don't know what the outcome may be. These are some of the things you need to consider. Security, do you have security payments to a security company? What about maintenance? You live in a complex and you need to pay maintenance. Can I get the next slide, please? Tax payments, motor vehicle payments. I mean, are your taxes going to be due around this time? How will they be managed? What about your motor vehicle? Are all of your papers in order? Is someone expected to drive while you're incapacitated? Are they on the insurance? Do you have a support team? You have a housekeeper, your gardener? How are they going to be paid? Are you going to need to ensure that you have systems in place for somebody to be paid to take care of you while you're recuperating? Now, also, do you need to give anybody access to your email to answer questions and so coming in from clients? Do you have a safe in your house? Determine if that key person will have access to it. What about access to your bank accounts? Who else has access to your bank accounts? I mean, if anything happened, does anybody have access to pay anything for you? Sandra, you never thought of this, and it's something that we always need to just have in place because we just never know what will happen. Passwords, who will have access to your passwords? Now, you go off to surgery, you have your secret password, something happens to you. Who can check your WhatsApp? Who can inform your clients? Who can even get into your phone? Is everything just locked off after? So sometimes we're thinking just about the actual occurrence of this illness that's causing us to do surgery, but we need to also take that step back to ensure that some of our fears are dealt with. Next slide, please. Sometimes we have, for those of us who go to church, we pay our tithes. How are your tithes going to be paid? Do you help anybody like on a monthly basis with their school fees? Is that going to continue? Have you put anything in place? What about your next of kin? Who is your next of kin? Who should the doctors and nurses know is your next of kin? And in our next part of this episode, we're going to talk about things like power of attorney and how do you actually set out what your decisions are. Do you want to be taken off of ventilator or off of life support after a certain time? Do you want to stay on life support? What are some of these decisions if you're going into any major surgery? What about your secure, confidential documents? And let me tell you, sometimes we have some love letters that we don't want anybody to see. Sometimes we did have some little things on some piece of paper, contraband. I don't know what we have. Who is going to scrape these things up and ensure that they're put one side? Again, key persons. And this actually just leads into the whole concept as we are thinking about the preparation of a will. Now, a couple of things. Truth asks, can I write a will without using a will form? The answer to that is yes, you can, Truths. You can write a will without using a will form. And we're going to go through tonight some of just the key clauses that you will have in a will. The important thing is whether or not it is typewritten or handwritten, it must be in writing. Truths, we'll get to that question. What's the difference between a power of attorney and a guardianship agreement? A power of attorney is a document that you allow certain persons to act on your behalf. So, for example, and you are overseas and you want your property in Jamaica to be dealt with in a particular manner and you're not here, and you give to a close associate a power of attorney to conduct certain business in regard to your property. It has to be signed, it has to be sealed. It is an official document because you're handing over, you're delegating some things that would have normally been your legal obligation to someone else. A guardianship agreement is in regard to children. I'm not sure, because usually it's a guardianship arrangement that is made where children are concerned. So you can get a little more specific with that question. Now, when you're thinking about your will, a couple of things that you need to consider. As Shelley says, the organization that I work with created a will drive. Lawyers visit the different locations and assisted us in preparing a will. That is fantastic, Shelley. And we're encouraging you in your organizations that you treat this concept of a will preparation. It is very, very important. There's so many times that person's assets, we're unable to dispose of them. Your children, there's a long period of time that your children cannot get proper care because there was no will in place. Now, create a list of all of your assets. And you know how we love say, me not have no asset. Me not have not a thing. Me not a thing for will. And I always say, make you go dead. You will see just how many things you have that you needed to identify beneficiaries, and you needed to ensure that you put things in place. So create a list of all your assets. Land. So the land would include where your house is. So the house that you're living in is your name on that title. And just to point out, in Jamaica, we have something called joint tenancy, or we have tenants in common. If you're a joint tenant, it means that if one of the joint tenants should pass away, the entire property goes to the other joint tenant or joint tenants. If you're tenants in common, you can actually, in your will to somebody. So you can actually devise to somebody, give to a beneficiary your portion of that property. What about your bank accounts and the financial institutions that they're held in? What are their account numbers and financial institutions, your banks, your credit unions, etc.? Now, insurance policies, one of the things that we usually advise, and your insurance agent will say to you, who is your beneficiary? You say, sometimes we have, even in the organizations that we work, we have life insurance, etc., that's provided by the organization. We don't want to fill out the rest of the form. When we get the work, we did so happy. We just fill out the top part or name, and we say we'll get back to you to tell you who our beneficiary is. In the event that you have an insurance policy that does not have a beneficiary, it means that the insurance would not be paid out to that beneficiary, and the money would now, the insurance payment now becomes a part of your estate. Okay, and remember, if you didn't leave it to anybody and it's not dealt with in your will, it now becomes part of intestacy, which we'll talk about later. What about your share certificates? Other proofs of ownership of assets, where are they? They're in a bank vault. Do you have any jewelry, paintings? Who will be your beneficiaries and what will they receive? And include their relationship to you. Now, the beneficiaries ensure that they can be easily identified. The names and addresses and occupations of your executors. Now, we're going to get to executors now. And where executors are concerned, somebody asked the question, should my trusted attorney be my executor? If your trusted attorney wishes to agree to be your executor, definitely. It is advised that you have at least 2 executors, and ensure that your executors know that you had noted them as executors, so they know that they're executors to your will. So ensure that you're having that conversation, and it's persons who can actually be proper executors of your will. Who will take care of your minor children? The name and addresses of the persons who are to be appointed legal guardians of your children. Also, list your debts and liabilities that you have to date. So this is what we're doing first. We're saying, let's just make a list of all the things that we need to consider. Now, we certainly, where you have minor children, ensure that you put arrangements in place. We're going to get into the nitty-gritty of wills, but just to throw it and to remind you, when you get married, your will is negative. So you did put together a nice will before you got married. Nice will. Everything set out in there. Right after you get married, the will is negative. So you actually need to create a new will. So add that to your checklist. Do I need to create a new will? Tip top, let me jump into this question. Is there a time frame within which an executor has to probate a will? Yes, the laws actually speak to that time frame, but the thing too is that in several instances there may be complexities in your estate and it may take longer. The longer it takes is the more expensive sometimes it becomes, which is why estate planning is very critical, and identification of who your beneficiaries are, where are they located, all these things. Truth says, my cousin passed away without leaving a will. She had some share certificates with just her name. How can her children benefit from those shares? No, she didn't leave a will, which means that, and I'm going to get to this other concept. You know, have you ever heard about intestacy? Now, we have a legislation that is going to wind up my mouth, but it's the Estates Intestacy Act. It's Intestacy Act. This is where you die without leaving a will. Does that mean that your family cannot benefit? It just means that the government has actually set out in legislation, so in the law, how your property is going to be divided up because you did not leave a will. We strongly recommend do not let your property get into that stage where it has to be divided up. Choose who your beneficiaries are. And also, if you currently have a will and you're saying to yourself, I've got it all together, I have a will, go back through this checklist. Have you identified all of your assets? Have any of your beneficiaries changed? Are your executors still alive? Are your executors still persons that you can trust? Jessica, does this mean that once you passed on, the power of attorney is no longer valid and the executor is the POA? No, a power of attorney and a will are 2 different things. A power of attorney is when you're certainly alive and well, and you're setting out certain business that people can do on your behalf, and you're signed to that. Your will now is going to be probated. So the business of managing your estate after you've passed, ensuring that your taxes are paid, the estate taxes are paid, and the beneficiaries get all that they're to get, that is part of what your executors do. So don't just pick executors, because you said to yourself, oh gosh, I like Shelly and Elliot. I like her. She's a nice girl. The question is, will she actually do all that is necessary to have your property, your estate probated? Can I have the next slide, please? Shelly Ann, that is such an excellent question. Does this mean that once you passed on the if your decision is to share all your assets 50-50 between your beneficiaries, is it necessary to detail everything? Now, that's an excellent question. Now, I'm going to go through, just hold that question for a moment, and I'm just going to go through the different specific areas of the will. Now, you may have heard this term testator. You know, lawyers come up with these words, you know, testator. Testator is really the person that is making the will. And your will is your last will and testament. So that's why it is framed. This is the last will and testament of me. And you put in your name. So the will must be in writing. Again, the will must be in writing. I'm also going to go through, as we're talking through, all the other musts of a will. So this is where you fill in your name. This is now, if your name is John Brown, otherwise known as Big John, that Big John is your AKA, put in that AKA. Many of us in my lovely little island of Jamaica, we have a name on our birth certificate, and they call grandmother. So our birth certificate name is Jennifer, what they call Pansy. Ensure that your full name is set out. Include your middle name. Make sure you're spelling it correctly and put your aliases. Now, I appoint, and this is where you put in the name, address, and occupation of your executor or guardian to be the executor or guardian. Now, this is where you are specifying the various persons, like if there are any guardians of your children, if the executors are going to be guardians, or trustees. We're going to get into the detail of trustee kind of setup. We're going to just touch on some of those things in the next episode. This is where you're setting out who your executors are. Again, ensure that your executors are trusted people who will actually carry out your wishes, that they know they are your executors, and when you have created a will, continue to transfer it to the alignment instrument until you pass away. So you need to constantly check, are these persons available to still be my executor? No, Shellyan, I give and devise. This is where you're going to describe what we call the real property. Now, the real property is like land, your house. So you need to say, who describe where that house is, so the address, the phone number, and the name of the beneficiary or beneficiaries. Now, you may say that you give, devise, and bequeath all of your real and personal property to your two children, 50-50 between those beneficiaries. But you can actually do that. I like to err on the side of caution and be very clear what we are devising, so that we can be updating that list. But you can also do it 50-50. I see Mishmak says, Rochelle, what is not hearing me or seeing me? Producers, can you just go back to the previous slide quickly? I just want to ensure that I cover that last point. Okay. Move on to the next slide. So your personal properties, such as the cash and bond, jewelry, you will give and bequeath those. And you for this, we'll also put this wording for you, or you can actually just say that, just specify what you're giving if you are writing it yourself. Is everyone here clearly? Or am I warping? Important information. So let me continue. Now, there is a very important clause called a residual clause. This is where you say, I give, devise, and bequeath. So again, give, devise, and bequeath. This is where you're talking about the rest and remainder and residue of your estate. I'm not clear? One second. Thank you very much. I'm glad you're paying attention. I'm back. I hope you're able to take in all of that information. I was stuck a while ago. I hope I was not stuck with my mouth open. Is everybody hearing now? Just give me a thumbs up. Are you hearing? Hooray, I hear hooray, we're back. Sean says nothing at all. Producers, are you hearing me? Opal says great, very clear now. We're back. We're back in business. So, I was talking earlier. Thank you, Blair. You see, I like this kind of, you see the engagement. Somebody did have a pop up, jump up, so we can see or a perfume on, oils is on. Now, there's a very important clause that I was talking about earlier, the residuary clause. And that residuary clause, now, listen, you say to yourself, listen, I don't have nothing now, you know, all I have are the one car, I have some shoes, I have some furniture in the house. I plan to buy one house, but I don't have one right. No, I rent. And you said to yourself, but I don't have nothing to give and bequeath to anyone. The things that you have now still create a will. Now, what the residuary clause does is that it kind of scrapes up everything that you have not identified in the will, and it identifies a beneficiary or beneficiaries that they should go to. So, for example, if you had done a will a long time before you didn't make so much money from the business, and you didn't identify all of these houses and property that you have now, that's what the residuary clause does. Again, though, you want to constantly, Shelly, you're just taking the words of how often should the will be revised? Do I take my own advice on this? The best advice is that you do this as an annual, you know, the same way you're doing a vision board, do this as an annual exercise. The same way with your organization, you're doing a strategic review, do that strategic review on a personal level and ensure that you're updating your will. Now, one of the things, Shelly Ann, is that we're going to, in part 2, talk about some of the things that negative your will. And we want to ensure that your will is always up to date. Remember, I talked about marriage, that marriage negatives your will. But for example, suppose one of your executors has passed away, that you should have updated your will with a new executor. Suppose one of your beneficiaries is now deceased, for example, you want to also ensure that you update it. But you remember, it's your property. Suppose you don't like your beneficiary them again, and you want a whole new set of beneficiaries. It is your last will and testimony, and it's your property. So you can give it and divide it in the way that you choose. No, the testator, the clause in witness whereof, where I set my hand to, etc. You know, sometimes we look, set my hand to, what I mean, where you sign. Now, the will, one, must be in writing. The will must be signed. Who is the testator again? Remember, I mentioned the testator is the person who is making the will. So the person who is making the will is the testator, and you must sign. No, Mishmak, I'm a member of a credit union. They said that who I list as beneficiary takes precedence over whatever is in the will. Is that correct? No, that's a difficult question to answer because I'm not sure what they're speaking to in regard to the credit union, but I'll also just double check to see what are some of the documentations that are signed in the credit union. Now, for insurance, I do know that you can have a beneficiary to your insurance who is not identified in your will. So you could have John as your beneficiary, John Brown, in your insurance, and John doesn't even appear on your will. Now, if, for example, John Brown is your beneficiary in your insurance, that insurance document would take precedence because you've already technically willed out through the insurance policy to John Brown. Okay, so I'll double check on that nomination form and I'll have it as something that we'll answer in the next episode. I just want to ensure that it is operating in a similar way as insurance and not speaking out of turn. Now, the testator, that's you must sign in the presence of witnesses, and you should sign in the presence of at least 2 witnesses. What does this mean? You must sign in the presence of witnesses, which means that the witness them must be there when you're signing. So they must see you sign the will, because what they are actually witnessing your signature. And the witnessing of your signature is very important because sometimes when wills are challenged, it is those witnesses who have to come and say that I signed and I saw this person sign the will and see my signature there. I signed saying that I witnessed it. Now, one of the things that when I was in law school a few years ago, that I always found it always made me kind of laugh because you know how I said before that we don't love people know our business. So sometimes even to get the will witness, we don't want nobody witness it because we don't want nobody to see what we will. The people are not witnessing the content of your will. So they're not going through to check to see who your beneficiaries are. What they're witnessing is your signature, that there is a will and testament, and they're witnessing your signature. So each witness, you must sign in the presence of each witness. And the section for signing, don't put it, sometimes when we type it up on the computer, we print it off and the signing pages are on a different page than the body of the will. Put them so that the signing page actually falls, the signing and the witnessing falls, so it captures some of the body of the will. And I also encourage that each page is initialed by you and by the persons who have witnessed. The will must be, so this is another must. It must be in writing, it must be witnessed, and it must be dated. Dated, because it's your last will and testament. So guess what? You do all of the things and you don't put a date on it. You're saying to yourself, I'm going to think a little bit more about it. I'm going to put next week date on it. The last will and testament is your last dated will. That is a valid will. So whether or not at the point of your death, those were the beneficiaries that you still wanted to have, if you did not update the will, it's your last valid will and testament. Now, Nicola Bright asks, does the witnesses have to be JP? No. Not at all. The witnesses just have to be persons who can see you sign your will. So they don't have to be JPs. Also, I have had situations where the will is witnessed, there is an issue with the will, and you know how some of us have some signature that is like scooby-doo, squiggly-dee, and you can't see who that person is. ensure that whoever witnesses your will, that their name is clearly printed out so we know who that person is. Okay, I see another question. Do the witnesses have to be in the same room while you sign? Indeed, they do, because they need to see you sign. What they're witnessing is that they saw you sign. Now, it is highly recommended that you make a copy of your will and include it in documents that you have in that list of your documents, and also that this copy of your will says where your original will is. Now, let me tell you, some of these things you say to yourself, really, Doroshan? Yes. Many a will, nobody knows where it is. Many a will has been made and property ends up going into intestacy because nobody don't know where this will is. Nobody even knows that who the witnesses were. Worse too, if you didn't identify your executors to the executors themselves, for them to say, you know that they asked me to be executor, or when you pass, somebody says, you know I witnessed a will. Where is that will? So ask yourself always, where is my will? Who knows where my will is? Kevin Dean asked a good question. What if the witness dies before you? Usually you rely on the other witness, but if the witness dies before you and you know that the witness has passed, please do over the will and get 2 other people to sign. It's a dynamic document that you have to pay attention to. So, excellent question. Now, ensure that the will is in some kind of sealed envelope and stored safely. Now, I've had a situation where a will was kept in a drawer and there was some flooding in the house. And when the will was found, what had happened is that there was flooding, the will had dried in the envelope, and it pretty much fell apart. Okay? Please don't ask me what happened with it. Quite a nightmare. Now, nowadays we have some good envelope, some good envelope. Some envelope will have some plastic things inside, and so ensure that you don't just use an ordinary envelope. This is your will and testament, Many of us have children. We want to ensure that our children are taken care of when we pass away. Don't put it in a little flimsy envelope that if little rainfall and the place flood out and stuff. Because with COVID-19 now, we know that anything can happen. Ensure that it is in somewhere safe. Ensure that it is in somewhere that it is not easily destroyed. Now, I see the questions coming up. Truth said, should the witness have been known to you? Many a witness has been the paralegals in a law office. No, they do not need to have been known to you. They just need to have seen you sign the will. Your executors should be known by you. So they only need to see you sign the will, and they're signing that I saw you, Truth, sign this will. Annette says, if you get married after you make a will, does your husband or wife have right over persons on your will? Now, Annette, I had mentioned before that upon marriage, your will is negative, so you actually need to do a new will. So, yes, your husband or wife will have some, let's not say right, but some precedence over other persons if your will is negative, which means it's not valid no more. So have no will. Even if you did a will, it's treated as if you have no will. So you would have died intestate, which means now that it would be dealt with through the Administrator General's office under the particular legislation. And husband and wife rank very high in the distribution of your assets. Now, one of the questions, one of the things that are asked, remember too that sometimes we have some husbands and wives who we're not together again, but we did still never do anything. So they're still of note as your husband or your wife. You don't have any will. So the property is going to be disposed of in a particular order according to what the government has set out. And husband and wife, whether or not you like them at the time of your death, whether or not you're properly together, if you had not dissolved that marriage, you remember the property is going to be distributed in a particular manner. Judith, oh, let me answer Janice first. Janice, I love these questions, guys. Where's the best place to keep your will? If you have a safe, put it in the will. I highly recommend, if you don't have a safe, get one of those envelopes that have the plastic inside, one of those airtight, waterproof type envelopes, and you put it in there and you put it in a drawer that you keep most of your important, because you treat it as an important document. Wherever you keep the title for your house, your will should be somewhere near there. Wherever you keep the title for your house, your will should be somewhere there. Not sure if you've addressed this before, but can an executor be a beneficiary? An executor can, in fact, be a beneficiary. Not, I wonder how the government of Jamaica will recognize the PSO. Thank you, Dr. Smith. Shelly-Ann, when the will was being signed, I observed that the order of the initials took the same order as the full name and signature on the last page. I guess this helps to solve the fancy signature issues. Yeah, let me tell you guys, there is nothing like a fancy signature that you don't know who the witness is. And you know, sometimes in witnessing documents, you see something to witness documents, and you say to yourself, what is the importance of witnessing? Make your trial prove said this will was signed. The witness is critical. What if you're in a common law relationship living together for over 7 years? Now, common law unions in Jamaica are recognized as 5 years and over. You have to stay tuned to episode 2 of this WILLPower, because we're actually going to go into some of those nitty-gritties. Sandra says, how do you go about getting legal guardianship for a relative who is unable to care for himself or herself? Sandra, that would be, because that's a whole body of things, so that we can include that as something that we deal with in our future episodes. So I will note that so that we can provide some better information. Or a perfume, but someone will need to know where the will is just in the event you pass. Yes, or somebody has to know, which is why we say you always identify key persons who know where your will is. Ensure your executors know that they're executors. Tell them where the will is. So you can lock up the will in the drawer, you know, but somebody must know that the will is in your drawer. Now, it is highly recommended too that you go to your lawyer, and that your lawyer keep your will for you. But if you're doing it on your own, because you can do it without a lawyer, but also if you have a complicated estate, go to a lawyer, get the advice of a lawyer, and ensure somebody knows where the will is. Cecile says, or just put will in an envelope and then a Ziploc bag. Great point, Cecile. Sean says, for a partnership business, who makes the will to decide on the sharing of the assets? For a partnership business, Sean, it is going to be very important how that partnership is structured and what it says about how you divvy up the partnership. Now, if the partnership is structured correctly, what will happen is usually there's a percentage of that business that that belongs to you as a partner, and you will have in there arrangements of how that partnership will either dissolve and become something new, or that your beneficiary will now be the beneficiary of your portion of the partnership. Nicola Bright, is it important to list all assets given to the individual, or does state 50% of my assets should be given to my son? Nicola, that's a very, very good question. Now, you could say 50% of your assets should be given to my son, and that would generally cover all of your assets. But notwithstanding, if identify the assets, there is that residual clause that you can identify anything that you have not listed. Also say in the residual clause, make sure that clause is in there, you know, where it says pretty much anything that you have not given and bequeathed. This is how it should be disposed of. Lisanne Drummond says, I'm one of 3 adult children left in the house that belong to mom and dad, but they divorced now. My dad is dead, but no will. Not sure. It sounds a little complicated, Lisanne. Now, guys, as you go through, you will note that you have seen over the years many different things happen to estates. I go to a lot of funerals, and I always say that there is nothing like when you cannot rest in peace, because the beneficiaries that should be taken care of, especially your children and your spouse, that they cannot be taken care of because you have not created a will. Do not let any fear of death address you not creating a will. Consider it that it is in fact irresponsible for you not to deal with planning your estate, dividing up your estate clearly, creating a will, ensuring it is in writing, ensuring that you have executors, it is signed, and somebody knows where it is. Prepare your will. Can an NHT refund be a part of your assets when it goes into that bank account? Whoever you had left that the money in that bank account to, or if it was not covered before, that residual clause would deal with it. So think again, who are your beneficiaries? Your children, are they properly identified? Your minor children, are they going to be taken care of? Now, I see that we have I'm seeing the questions coming in because this is an area that we all want to get clarity. There will be a part 2 because we resume on April 9th. We're going to take a break next week, Thursday. It's Holy Thursday, and we have lockdown and lots of complications. So we will be back and we will get into further nitty-gritty of the different things that you need to know about your will. I'll take this last comment before we bring on Andre Robb, who's going to tell us about a technology platform that helps you with creating your wills. I don't mean to belabor the point, but I was told that a witness can be in another room while you sign, as long as they can see you sign. Now, Opal, let me tell you, true, them can peep through the window. The people don't need to see what is in your document. They don't need to see who your beneficiaries are. They need to see that this is your last will and testament, and they need to see you sign. So I take your point. They could peep through the window, but I would say you would want the person over you seeing your sign. In the event there's a problem, them can know, say, the window was not blurry. They actually were right there seeing your sign. Let's do it that way. Mishmax, yes. We're here to serve, and we are providing additional information. Again, please join us for episode 2 of Willpower, because we want to make sure you are in a position that your assets are protected. You're going to be doing all of this business because remember, we're going to be thriving out of COVID. Ensure that your estate is planned. Now we have a gentleman who is joining us. He is a CEO and founder of Will and Tomorrow. Will and Tomorrow was founded by him. He is, in fact, he's a social policy specialist turned entrepreneur with a leaning towards socially minded ventures. Andre previously launched Driving Change Academy Limited and was a partner in Icon Media and still runs, and I know a lot of you know, Box and Company. He has benefited from the generous contributions of business support programs from the Jamaica Business Development Corporation and the U.S. State Department's Young Leaders of America's initiative. Ladies and gentlemen, please join me in welcoming Andre Robb.
Hi, everybody.
Hi, Andre. How are you?
I'm good. Are you hearing me all right?
Hearing you well. Now, Andre, you did quite a pivot, because I know you from Box, and I love me some Box.
Oh,
Can you just
introduce
by telling us a little bit about that pivot from Box?
Well, it's not really much of a pivot because Box is still alive and kicking and keeping me busy and keeping the rest of us busy. But with COVID, we've seen a decline in just how much people are willing to spend on our very nice and wonderful gift boxes because, times have changed. So we saw a decline in demand early into COVID, and stuff started picking up again. And during that time, I just had a lot of different things happening and landed on the idea of making Will and Tomorrow a reality.
Okay, and I see. Hi, Angela Robb. Angela says hi, Andre. So does Sean. No, Andre. Why Will and Tomorrow?
Yeah, why the name or why the venture?
Yeah, why this venture? I mean, exciting venture, but what caused you to go along this road?
Yeah, I've always loved the role that technology can play in making lives easier, and I am an egalitarian. So I believe in people being able to access things, not just have it be reserved for, you know, um, the most entitled or people who have a lot of money. So with Will and Tomorrow, I got the idea to make it easier to make the conversation happen a bit more frequently about preparing for the inevitability or the eventuality that a time will come when we need a will. So that's it. I like to make things easy for people. And then when I saw myself as someone who's been gathering assets here and there, making multiple businesses and not having a will and could have needed it, I was just like, no, it's time to sort myself out. But while sorting out myself, make it easy for others to do that as well.
Okay. Can you tell us a little bit about the platform Will and Tomorrow? What does it, how will it help us?
So I believe it will help because, you know, just as though a lot of people have a lot of questions because we don't have conversations about wills all the time. I love to see when we have the kind of riveting conversation that we just had with you, Rochelle, where all the questions were flying and people were people were showing that they were beginning to understand better everything that goes into making a will and why estate planning is important. Will and Tomorrow as a platform allows for us to share resources, to talk about making a will, to go into some of the topics around, you know, if you're a parent of minor children, these are things for you to consider. What do you consider before you make a will? What are the parts and components of a will? Breaking that down in everyday language. Because I'm not an attorney, and so I'm not coming to this with that particular personal experience as an attorney, but as someone who creates solutions for a living as an entrepreneur. I was able to, you know, pull on the expertise of the attorneys, pull on the expertise of the programmers, pull on the expertise of the designers, because we pay very close attention to how things look, how things are presented, so that at the end of the day we have a full experience that people are happy with. So one more thing about what Will and Tomorrow is and how it can help is that we provide the education, but we also make it easy for you to go through the will making steps, which are the questions that you would answer and you would tell to an attorney if you had involved one personally to create your will. What we do is we make it cheaper and easier for you to do in the convenience of your home to answer these questions, that once you provide the answers that you want your will to contain, at the end of the day, we use the technology to generate a comprehensive will document just for you, the person who's answered the questions.
Okay. And I'm sure you have the relevant disclaimers that says that this platform does not in any way substitute for proper legal advice.
Correct. Because we don't want nobody knocking on our doors.
Yes. So this is, you know, for many of us who over the years have, you know, run into a bookstore and picked up a will form. This is actually a technology solution to help you to prepare your will. Now, tell us, when somebody visits your website, can you take us on a journey through your website? What will they see? What are the particular things available on your website?
Certainly. I mean, I had prepared some slides. I don't know if we can show them now, because in addition to talking through the steps, it might be good for people to see. So if we can, until the slides come up, I'll just tell you, you can go to our website right now, www.willandtomorrow.com. And when you land there, you're going to see our value proposition. And our value proposition is that it can take you 30 minutes. It can take you even less if you have thought about the inputs that are going to be a part of your will. If you've thought about them from before and you now go to our website to just type them in, then it can take you just that amount of time. But it will take you longer to think about the parts of your will. So if you go down some more in the slides for me, you'll see what it's like to create a will on Will and Tomorrow. So you land on the home page, which looks like this, and you see the various headings. If you're landing there for the first time, you're going to be encouraged to register for an account. So just as though you have an account for any of your online platforms or tools, it's the same thing with making an account on Will and Tomorrow. You create one just for you. So you'd start by clicking register or start here and then go to the next slide. And you'll be taken through a series of pre-qualifying questions. So what we've done with Will and Tomorrow is to create a super template, that have all the language that you talked about earlier, Rochelle. When you're talking about naming the executors, you have to put in the information as to their occupation and their address. And it says, I appoint this person to be my executor/trustee. And all of that language that I didn't write myself is there. But before we do that, we have to ask you, do you live in Jamaica? Are you over 18? Things like this that make it a good use of your time. Because we don't want somebody who hears about Will and Tomorrow that is based in New York, but is a Jamaican, and they want to make a will and they just jump on Will and Tomorrow and think that our form is for them. It's not. It's for people who are resident in Jamaica. All right. So once you go through that and you create your account, which we just saw a slide for, then now you have an account and you are ready to prepare yourself to write the will. But you just went through all the preparation stuff. We just have this very simple printout, or you can do it on your laptop or your iPad, that allows you to write down the details for some of the things that you need to think about beforehand. And so our will prep list just asks you to note the names of your executors and make sure that you ask them stuff that you just told us that's important for us to do. List your assets, list who you want your guardians for your underage children to be, and also to think about your final wishes, because we ask that of you as part of the will making steps. So once you do this offline bit, you get back to willandtomorrow.com, you log into your account, or maybe you didn't close it, and then now you if you go to the next slide or the next couple of slides, you should see what the back end of our will making steps look like, right? So just go one more slide down, right? So when you land in the dashboard, the first and only thing that you'll see is the prompt to make a will. And you click on that and it takes you over to the will making steps, which we've categorized the questions into 7 steps, right? And you go through step 1, tell us about who you are. Go through step 2, tell us about your children and if you have guardians for them. Go through step 3, you appoint your executors, and it goes on from there. And you are only prompted to pay for our service, because Will and Tomorrow is a business. You're only prompted to pay for it at the end of answering the will making steps. However, because of popular demand, we've also created a way for you to pay for the will before you answer. And this is actually for people who want to purchase it for somebody else. So like people overseas, the same person in New York wanted to have a family member in Jamaica create their will on Will and Tomorrow, and they wanted to pay for it with their credit card on our platform. They're able to go to our website and to pay for the will up front. And then they get a code which the person who is creating the will themselves, instead of being prompted to pay and entering payment details, they just enter that code. So there are actually 2 ways to pay for making a will on our website. And you can see here what our prices are. And hopefully people find that to be within reach. So you did all of that, you get to the point where you've paid for it. What happens after that is that you would have submitted it. We get it on the back end. You are not able to see your will just yet. It goes through a manual process of review by a team member at Will and Tomorrow and also an attorney. And then within 2 business days, we upload it to the back end. You get an email to say your will is now ready. You can log back in. You click view will. You see your document. You read it through. It makes sense to you, or you have a question, know that you're seeing the language, you send us back a note, and then we rectify that. Usually there is not too much back and forth because, we try our best to deliver something that works. And at the end of the day, you get a downloadable document, but we also send you a physical copy in the mail. And that's what Will and Tomorrow is.
So you get a physical copy. And just to remind that when you get this copy, so one,
you're not finished because you have to get it signed.
exactly. So getting a copy of it in your email, in the same way, typing it up on your computer alone and printing it off and putting it in your drawer is not a completed or valid will. It must be signed and witnessed.
Right,
Okay.
exactly.
So, and I'm seeing some comments. Dr. Smith says, it's so beautiful to see how creative and innovative our Jamaican millennials are. Sean says, can you get multiple copies for that cost? I suppose you can.
You can print as many as you want.
Okay.
Yeah.
You have another slide on.
Oh yeah. So right. So we also have another product in Will and Tomorrow that we call Will and Tomorrow for Businesses. And what this is that if you have a group of you who've identified will making as something that's important for members of your organization to do, just like someone in the comments said earlier, that they were a part of a company that had attorneys come in and talk to them and encourage people to make wills. A lot of times business owners can play that role in encouraging people to do that. And so we've created a product where if you have a group of you and you are from an organization, you can reach out to us via a page on our website, which if you go to our website now, you'll see 4 businesses in the header menu. And on that page, you see the details as to what's included in this package, where we have an online session like this with an attorney and somebody from Will and Tomorrow who talks about the platform, but also goes into the overview of making a will, very similar to what we've done tonight, but just for you and your people so that you can have a more intimate place to ask questions. And so that's one part. And then you also get a discount because you are taking quite a few wills from us. And then you also get what we give to everybody in terms of the reviewing by our team members and attorneys and the printed document and some hand holding as well. So there is a possibility for business owners who are here tonight to go to our website, see if that looks like something that they're interested in, and shoot us a message right on that page to get started with a Will and Tomorrow for Businesses package.
Okay. Well, Andre, very interesting platform, and it is great to see technology that we are moving to that stage too, that we are using the technology. And I see questions coming in, but a lot of commentary. Sean says it's a fabulous idea. One of the areas to the in the market that is with the various insurance companies. So, you know, what is happening now is that we're recognizing there are some simple things that persons need to have in place, that there are business opportunities that come from it. So thank you for what you're doing, Andre. But also that this is something that is very important. Again, please, none of what we spoke about today substitutes for you getting specific legal advice on your estate. There are always nuances to various estates, how your properties are held, lots of nuances, especially to when you're looking to build any kind of trust for your children, guardianship relationships, etc. You want to ensure that you seek the relevant legal advice. So this is not intended to substitute for you going to your lawyer. However, you can actually create your will on your own, and there are some important steps that you need to follow. Andre's website, Will and Tomorrow, is a facility that is available that is a little more high-flung than the will form that we used to pick up. Andre, you're saying something?
Yeah, I'm saying that I also underscore that point that you just made about how when we said, you know, we're going to put this out there, the number one reservation was that, wow, you know, wills are so important. They have so much consequence. We should probably just encourage people to continue to, you know, go through the route that we've tried and tested, which is getting your legal advice. And we still advocate for that. What we say with Will and Tomorrow is that you can use Will and Tomorrow and still talk to an attorney. And we are also keen to point out that we're not for everybody. So, you know, when your estate is complicated, when you do have a lot of questions, even within yourself, you know that, you know, for me to feel comfortable with creating my will, I do want to talk to someone personally. then we don't want you to go the route of coming to us. We prefer that you go to the experts in terms of attorneys to create your wills. But we also know that we have a population that we can serve, which are individuals that don't have that reservation. They have an estate that they feel comfortable with getting the guidance that our online platform provides and going through a questionnaire and seeing that, you know, they've asked me all the things that I've thought about or I've read about. And when I've asked my attorney what they thought about me creating a will, they also substantiated what Will and Tomorrow is doing. And for those people, we want to say, check us out. So yeah, I love that you reminded me to make that point, because I want everybody to remember it.
Yes. Wow, Andre, thank you very much. That's Will and Tomorrow, and Andre is also the principal behind BrataBox. So
Yes.
also, where can we find BrataBox again for those who don't know?
So BrataBox, best place to find us is on our Instagram page. Our website is still there, but I've put it behind a password just because we're rebranding. But BrataBox is BRAATABOX. But our Instagram is where you can send us a message anytime, see what our gift boxes look like, reach out to us and tell us that you want something.
Okay, thank you very much, Andre Robb, CEO and founder of Will and Tomorrow. So, ladies and gentlemen, tonight we have had our first episode in our two-part series. With all the questions coming in, look like we may have to make it a three-part series. We're going to be joined on our next episode by Camille Facey, attorney at law. I spoke to her just this afternoon. I hope she's watching, so she hear me calling her name. Now, ladies and gentlemen, we've talked about wills tonight. Remember, it is very important to ensure that you have a will. You should be 18 years and over, 18 years or older. I always say, as soon as you have even a pair of shoes and you're 18 years and older, make a will. Now, the will must be in writing. So that means you can write it with your hand and a pen, or you can type it. The will must, however, identify you very clearly. Make sure your name is clearly spelled out. Make sure any aliases you use, the other alias that everybody else knows you as, you put that in there. Your will is to be signed, but it must be signed in the presence of two witnesses. The witnesses need to see you sign. I saw somebody say, well, if you don't want them to see what's in your document, just fold it over. Just make sure that they are seeing that that is your last will and testament and that they saw you sign. Your will must be dated. Ensure that you're identifying your beneficiaries. We went through a list of the things that you need to consider when you're going to prepare that will. All of this information is available in this week's memo, and it's available on smallbusinessportal.com. If you do not currently get our memo, you can email us at sme@psoj.org. We will be getting into some further nitty-gritty of wills, but I want you to also think of a couple of things, because we're going on lockdown this weekend. So what a great time to put your list of documents together, to ask yourself, where is my car title really? Because it's a long time I pay for that car. Where's my house title? It's a long time I pay for the house. Where is that title? Does the financial institution actually have a copy of my title? Do they have the title? Do I have a copy of my title so I know what is on the title? Whose name, ladies, the name that is on that title? Did you change your name upon marriage? Should you need to note the marriage on the title? The property that you are seeking to include in your will, have all of the nuances of the property been dealt with? Is it the subject that somebody leave that property to you? Was their will probated? We need to let us not be caught by surprise. This is a business of our own lives. Let us take care of it. And let us put our beneficiaries in a position that we can rest in peace, because they are able to live in peace. They're able to easily deal with our estate. It's time. We have 3 weekends of lockdown. Let us use it well. Some of us are wondering what we can do with it. We can deal with the business of our own business. We can deal with our willpower. We've also included this week, and I went through a list of things that you need to consider to live in peace if you're going into major surgery. Some things you need to consider, but it's also time to kind of take that step back to organize ourselves, that whether or not you're facing anything, you're looking at anything in the near future, any kind of health crisis, you never know what will happen. Ensure you have your documentation together. We've provided you with a full list. Ladies and gentlemen, it's always a pleasure to serve you on COVIDCastJA, brought to you by the Private Sector Organization of Jamaica, committed to our micro, small, and medium enterprises thriving and emerging successful on the other side of COVID. We are here every Thursday at 7:30 p.m. Next week, Thursday, is Holy Thursday. We have a whole lockdown situation going, so we're going to take a break next week, Thursday, and we return the following week, Thursday. Oh, don't be shocked. Don't worry about it. If you have not been watching and this is your first time, there are 46 other episodes chock full of information. Visit us at smallbusinessportal.com. Scroll through our Facebook page. Use the time. Some people talking about Netflix. Use the time to binge watch COVIDCastJA. We will see you soon. Stay safe. Sanitize. Wear your mask. There's a fine. Wear your mask. We'll see you 2 weeks from now, April 9th, on COVIDCastJA. Stay well. So you have a great idea to start a business, but you don't know where to start. We completely understand. You have a lot of questions and almost no answers. Smallbusinessportal.com is here to help. At smallbusinessportal.com, you gain access to information on loans, grants, and investment opportunities from verified financial institutions. Guess what you also get? Useful business tips, access to training. All these services combine to make your business idea into a reality. Start your journey today at smallbusinessportal.com.